Man, I hate being ripped off, and you know, something being sold to you and only to find out it's not quality and probably has been stolen, or you know, such things. Nah, it's not cool.
But I think when guys they're checking credit, they have to know how much they're gonna pay and they have to protect it.
I think they're taken for granted, if I can say so, according to my experience.
Have you ever
my knowledge.
Have you ever been taken for a ride before?
No.
Well, I haven't had a problem, because if I go to the returns department and I don't get service, I shout. And they get embarrassed and they just help me and give me what I want.
So have you heard about the new Consumer Protection Act?
Yes, I have, but I haven't had to use it.
No, we're not protected. We're not fully protected. I've been taken for a ride some time back where guys were selling houses and we signed papers to buy the houses, but there was no houses. We gave them deposits and they was gone. But we signed papers and everything.
Welcome to the show. It seems that there are some consumers out there thinking that they have been ripped off in the past. And of course, this piece of legislation will help consumers and be protected against things like that. But Iona, are we good for 1st of April? Is it going to happen on the 1st of April? Or do we expect any further delay?
Jackie, I certainly hope it does. I mean, what we have currently we have a copy of an act that was meant to come into force on the 31st of October, in October 2010.
Yeah.
In terms of the act, the minister has the right to defer the effective date to a later date, and that's exactly what has happened. Unfortunately, we're sitting in a position where the regulations, which are very critical in assisting us to interpret and better and to implement the provisions of the act, are only in draft. My understanding is that DTA is working very hard to make sure that the final regulations are out before March. Failing that, I wonder how we'll be able to properly prepare ourselves for the 1st of April 2011.
But don't you think this creates confusion, Iona, with consumers? You know, it's almost like it creates this gap between when legislation came into or was passed and then comes into effect. Do you think consumers are confused because of that?
I wouldn't be surprised if they are, but I'm hoping that by reading the act and being familiarizing themselves with the provisions, they're gearing themselves in the best way possible. I'm sure the regulators are working as hard as possible, but it certainly doesn't put not only consumers, but as a supplier of goods and services,
yeah.
You need to know exactly what you're going to be doing. You need to prepare as best as you can, and it's unfortunately not possible or completely possible to do that right now.
But Fred, shouldn't businesses be gearing themselves already to be ready for before anything gets passed?
We have had workshops, sessions, and we have had conferences trying to encourage our members to get up to speed, to prepare themselves. Because bear in mind that come the 1st of April is an implementation time, is not preparing time.
Yeah.
So when that comes, it's up to you to comply. It's not about you trying to set some systems in place. So I think advertisers, agencies, marketers, they are up to speed. We have also attended some workshops with the DTI with the marketers, so I believe that they are doing everything in their power now to make sure that come the 1st of April they are compliant. But I just want to also add that in terms of the draft regulations which are out there, there was a workshop that was held in Pretoria. There was a big turnout, even though the DTI was expecting less turnout. And I believe that the comments are pouring in. And I'm confident that come the 31st of March, then everything will be in place.
Everything will be in place, and businesses then, like you said, should know what to expect and should be geared. But when it comes to consumers, Sue, does the onus lie on the businesses to educate their own consumers and tell them how they are actually going to be protected?
It's a really interesting question, and something that we've debated internally actually is, should we be proactively spreading the news about the Consumer Protection Act? And I think as a consumer myself, not to say that I'm not involved within this legislation, but I think it's been one of the most widely publicized pieces of legislation, and I think consumers are well aware of what's coming and exercising their rights. I think they're also excited to do exactly that. I think the onus really should be on both the consumer and on the industry to make this top of mind and to make it effective as it's intended to be.
So now the CPA covers a lot of information, doesn't it? So today I'd like to focus just on what it means for marketers, for advertisers, for information and disclosure. So Iona, over to you, if you can give us just a top line understanding of, under these themes, what the CPA is actually set out to do.
One of the things that are provisions that are quite important that will apply not only to advertising but to agreements and to any notice or document that is produced by a supplier is a provision that requires that document or notice, i.e. for example any marketing brochure, be set out or prepared in plain and understandable language. Now of course there are various debates in terms of what that means and what does, as speaking as a lawyer, I'm not exactly sure what plain and understandable language means, and I think as a lawyer myself we're going to have to try to ensure that we understand, because so that's one of the provisions, and there are also provisions that are particularly relevant to companies that engage in direct marketing. Huge consequences for that, where you have engaged in that practice. And just in terms of your labeling, just making sure that provisions that aim to ensure that whatever is advertised or marketed is not by any means deceiving a consumer, that you clearly understand and are able to understand from what's set out in the packaging, in any notice, you clearly understand, and to make an informed decision about the product that you're about to buy. So various provisions around marketing and advertising that consumers will be very happy about.
I think first of all, the clear and understanding language is ambiguous as to begin with. I mean, what have you guys found with, how do we tackle that part?
Well, look, there's obviously the labelling regulations that need to be considered in conjunction with the CPA. And the labelling regulations really specify that we should have our labels in English and, where possible, one other official language of South Africa.
Right.
So now whether one interprets that to be plain and understandable, or whether it's the specific words that are used on those labels, all of those things need to be considered by food manufacturers specifically.
Right. Okay, let's look at some implications, Fred, when it comes to advertising and marketing. What would you say, if you had to pick one, or is the major challenge for marketers going forward?
The major challenge that we have seen that is endorsed in the Act is paid marketing, where you find that big chain stores, they'll splash out advertising that they've got say.
That's it, yes.
And when you go there, you are advised that in fact the products that were on sold are sold out, but they've got new products that have just come in.
So they're enticing consumers in with a sale, but when you get there, sorry, we sold out, but here's something more expensive.
That is a major concern for South African consumers, because some consumers travel long distances to go and buy these things, and they end up not buying anything, or they end up buying items that they didn't intend to. Hence, I think that the Consumer Protection Act had to have a clause in it that deals with paid marketing. Is one of the important issues in there.
I find quite interesting, what the Act covers is unsolicited mail, stipulating that consumers have the right to privacy and disclosure, as well as fair and reasonable marketing. So not to be communicated after hours, especially late nights and weekends. Wow! Wouldn't that be amazing?
I think we're all happy about that.
That also is one of the issues that I think it will affect the direct marketers, because the time that they do their business is on weekends, when they know that everybody's at home,
everyone's around.
But now if you have to contact bulk of your consumers that are on your database between 8 and 5, and we are all engaged, we are in meetings, or we are driving, and we cannot respond to messages, we cannot answer your calls because we don't want to be caught on traffic fines. So if there are time frames, I think that is going to affect them badly, because then they will have to change how they do the business.
But what to do as a direct marketer then, Sue?
Wow, Kellogg obviously doesn't really market directly, but where we have had an impact is on, say, our databases that we're using. So that would be considered direct marketing, I suppose. We have to give consumers the option to opt out.
Yes.
So an unsubscribe feature, for example, or Well, I mean, I guess that would be the biggest implication for Kellogg, and it's one of the things that we're doing already anyway. And an annual check of the database to ask them, are they still willing to participate in these sorts of marketing activities?
I think my sense is that what's going to be a challenge for some of the suppliers who do have an opt-out provision is actually making sure that they record the fact that a consumer has opted out. Because I think, speaking for myself, I have opted out on various occasions and still receive emails and SMSs notwithstanding having done that. So I think as a supplier, just prepare yourself and make sure that your systems that you currently have actually do work.
But I think one of the challenges that consumers must also be aware of is that you subscribe to a certain organization, but that organization has partners.
Yes.
Now
which they sell the databases to.
Which they sell the database or they share.
That's it.
So at times you opt out on this organization, but you find that your name and contact details are spread all over through the organization.
Sometimes we get emails from companies we've never even heard of.
Exactly. And Fred, I must say though, and I think this is, I'm not sure to what extent it's covered by the CPA, but in terms of protecting your privacy, I understand that there's a new bill, the Protection of Personal Information Act, which actually I think seeks to regulate the extent to which I can give a consumer can give his or her information to a supplier, and that information is shared without my consent. So I think as suppliers, let's just, not only is the CPA going to be relevant, but going forward, many other pieces of legislation will come in that require that you look closely at the way in which you market your practices.
Right. Let's look at while stocks last. What's going to happen with that?
I think that also ties to my previous point, that where you have sales and you invite people, but then what the Act requires and also what the ASA code requires is that if you say whilst the stock lasts, and we get complaints from the public that they came to your floor and there were no stock, and then we need proof that you had sufficient stock to satisfy the demand. But now, at times, if you find that you didn't have sufficient stock, it's then that we can say you engage in a practice that is in contravention of the code. And I think that the same standard will be applied to the Act.
Sue, do you want to care to comment on that?
Again, not really something that affects Kellogg's per se. It would be more at the retailer level where they're having stock problems, you know?
Yeah. Okay. Let's leave it there for now. We need to take a break. But when we come back, more on the Consumer Protection Act.